More and more student loan borrowers are wiping out their debts in bankruptcy. According to a recent paper in the American Bankruptcy Law Journal by law professor Jason Iuliano, 87% of people who tried to discharge their student loans in bankruptcy succeeded. Now, this finding completely discredits the long-held common belief that student loans are impossible to discharge and that they follow you to the grave. It shows that this belief is merely a myth, and it underscores that there's a genuine hope for those overburdened by student debt. In this segment, I review this paper and its implications for anyone overwhelmed by student debt. Now, fair warning, this segment will be data heavy, but I think it's necessary that we carefully review the numbers to show you the opportunities available to you. Before reviewing the paper, it's worth understanding why student loans acquire their mythical status as indestructible and why this myth persists. In short, it persists not necessarily because the legal standards are impossible to satisfy, but because the procedure for doing so is complicated, expensive, and time-consuming. In order to shed student loans in bankruptcy, filing your petition is not enough. It's the first step, but it's not sufficient. The extra necessary step is to file something known as an adversary proceeding, an AP for short. An AP is separate from the petition, and it operates like a regular federal lawsuit. Since it's a lawsuit, you'll need to follow the standard procedures, such as serving your creditors with the legal paperwork. You will need to go through the civil litigation process, which entails going through the discovery process. This is where you exchange information with your creditor. And you need to navigate motion practice, where the defense attempts to dismiss your case on the paperwork. Now, if your case survives these steps, you'll then need to convince a judge in a trial that your loans should be discharged. And even if you succeed, the other side may appeal. This extra process is necessary because the bankruptcy code gives special protections to student loans, which means they are not automatically dischargeable like other forms of unsecured debt, such as credit card bills and medical bills. Now, this procedure is perhaps the principal reason why student loans are notoriously difficult to discharge. Now, you can certainly attempt this process without an attorney representing yourself pro se. But the federal bankruptcy procedure and the rules of civil procedure are a labyrinth of complicated rules. Attorneys, in fact, take years to master them. So you can represent yourself, but you need to dedicate a great deal of time and energy. In fact, it has been done before. This leads me to the second reason why this myth persists: cost. Your chances of winning are generally greater with a lawyer, but you have to pay their legal fees. They don't work for free. And these legal fees are separate from the fees associated with your petition and adversary proceeding. Now, each step in this process, whether it be discovery or motion practice, will cost you. In one egregious example, and it's just one example, I don't mean it to be a sort of general concept, but a debtor was quoted $40,000 by a law firm because they viewed the process, I guess rightly, as extremely time-consuming and arduous. Now, as a side note, most attorneys won't charge that much. If you file for Chapter 13, you may be able to pay your fees over the 3 to 5 years of your repayment plan. In some circumstances, this means you won't need to put any money down. And so these are the reasons why this myth persists. The process is long and it's expensive. Now, although success is possible, this process has certainly discouraged both attorneys and people from trying. Now, while it is difficult, it's not impossible. 2002 was a pivotal year for student loans. That year, then President Biden, attempted to cancel student loans, which ultimately was overturned by the Supreme Court. What didn't make big headlines, though, was his bankruptcy policy. Now, that year, the administration implemented a policy that drastically eased the student loan bankruptcy process. The one responsible for this 87% success rate reported in this paper. Now, this policy is neatly presented in a guidance memo to the Department of Justice, which defends the federal government in student loan cases. And it was also directed at the Department of Education, which administers student loans. The guidance operates like an instruction manual. Look at it like that. It streamlines the court process by providing you with a simple attestation form that's filled and filed with your petition. And it also streamlines the legal test for discharging student loans, which ultimately reduces the amount of litigation. Even though this policy has changed the process, it's important to note a few things, a few caveats. First, the guidance applies to federal student loans, not private ones. Second, this policy is not law, meaning the government can disregard it when it wants. And third, the ultimate decision still rests with the judge, who can still deny your case. To see how this policy works, I need to briefly cover the law of student loans. Now, the bankruptcy code says that certain student loans cannot be discharged unless a bankruptcy judge determines that paying the loan would impose an undue hardship on you and your dependents. In 1987, a federal judge in New York elaborated on this rule in what became the landmark student loan bankruptcy case, in a case called Brunner versus New York State Higher Education Corporation. Now, in that case, the judge set forth 3 requirements you must meet to win these types of cases. First, you need to prove that you cannot presently maintain a minimum standard of living if you were required to repay your loans. Second, your circumstances must indicate that your bad present financial situation will likely persist into the future for a significant portion of the loan repayment period. And third, that you made good faith efforts in the past to repay the loans. This is the dominant test. It's the one used throughout many federal courts in the United States. But other jurisdictions use another test called the totality of circumstances test, which, as the name suggests, looks at all of your circumstances to determine undue hardship. Now, in all these tests, they are similar in the sense that they basically consider the same information, your financial profile and your future financial profile. Whether you're in a part of the country that uses the Brunner test or the other totality test, the law assesses 3 time periods: your present inability to pay, your future inability to pay, and your past good faith efforts to repay your debt. Now, in order to win before this policy, you needed to establish all 3 of these factors at a trial or convince the other side that they would lose before a trial. The difficulty with these factors lies in their subjectivity. For example, with respect to the first factor, that being your present inability to pay, with that factor, how is one to judge a minimum standard of living? Is eating out twice a month extravagant? In one case, a judge ruled that eating McDonald's once a week wasn't thrifty enough and thereby denied the person's request. How about a subscription to, say, Disney Plus or Hulu? Is that a luxury expense? And how about living in abject poverty? Does the law require that you live in abject poverty to meet the standard? Now, as much as the law is rooted in code and procedure and so-called objectivity, it often turns on the idiosyncratic judgment of a judge who's ultimately a person, and people are prone to make mistakes or to impute their beliefs on others. And how about someone's future inability to pay? How is that determined? Now, in some cases, judges have required debtors to demonstrate a certainty of hopelessness about their financial future to prevail. A certainty of hopelessness. That seems pretty bleak and dire. That was the problem with this test. Highly subjective and difficult. The guidance essentially directs the government attorneys to collaborate with you and to take a less adversarial approach, not to be so aggressive against you. It presumes you've satisfied the Brunner test and the totality test if you meet certain criteria, and it directs the government to recommend a discharge to your judge. Here's how that works. Regarding the first factor, your present inability to pay, the guidance will presume, it'll give you the benefit of doubt. It'll presume that you can't pay if your allowable expenses exceed your gross income. That is, if you spend more than you make. These expenses are outlined in the IRS's financial collection standards, which the IRS uses to determine a taxpayer's liability to pay delinquent debt. Now, these standards are broken down into three categories: national standards for things like food and housekeeping supplies, local standards for things like housing, utilities, and transportation, and the other category is what's known as other necessary expenses for things like childcare cost. Here's where the guidance becomes even more helpful. With respect to the national standards, the guidance allows you to expense your actual cost, even if they fall below the standards amount. So for example, the standard for food in a two-person home, in a two-family home, as of 2025 is $863. But let's say you actually spend $600. You can expense the full $863. The guidance also allows you to expense your actual expenses even if they are above the standard. But if you have a reasonable explanation for why a particular actual expense exceeds the standards. So for example, if you actually spend $1,000 a month on food, you can expense that amount above the standards amount so long as you offer a reasonable explanation for why your food costs this much. Perhaps you or your dependents have special dietary needs that raise the cost of your food. You need to share that information. Now, the calculation for local standards is different and not as generous, but still quite helpful. Here, the guidance tells the attorneys, the government attorneys that is, to limit your expenses to your actual expenses. In Brooklyn, New York, for example, the standards allow for $4,034 a month for housing and utilities. But if you actually pay, let's say, $3,500, which is below what a lot of people are paying, the guidance will limit you to what you actually pay. Now, other necessary expenses include things like, as I said, babysitting and daycare, and you can expense those up to the amount that they actually cost you. The main idea throughout this entire segment about these expenses is that these expenses have to be reasonable. And so the guidance also allows you to expense things that you aren't spending on, but need to maintain a minimum standard of living for needs that are unmet or insufficiently provided for. So for example, let's say you moved back in with your parents to save some money. Now the guidance will let you expense what you would pay if you found an apartment. You aren't making these expenses now, but it allows you to expense something that you would pay. It allows you to do so on the premise that people shouldn't be required to live in subpar housing indefinitely. The purpose of the bankruptcy system is to give you a fresh start so you can get back on your feet. So this policy makes sense. Here's the final point about this section. Even if you fail this part of the test, where your income exceeds your expenses, the government may actually recommend a partial discharge of your loans if what you would pay wouldn't realistically pay them off entirely. Now let's move on to the second factor, whether your current inability to pay will likely persist for a significant portion of the repayment period, your future inability to pay. Now the guidance will presume that this is the case if you fall into one of several categories, one of the following categories. If you're 65 or older, if you have a disability or a chronic injury impacting your earning potential, and of course, a doctor's note is extremely helpful. The third one is if you've been unemployed for at least 5 of the last 10 years, if you failed to obtain the degree for which the loan was procured, let's say you went to some school that closed down or somehow defrauded you, you would qualify for this part. And lastly, if your loan has been in payment status other than in school for at least 10 years. Now, these categories aren't the only ones though. If there's any other fact that you think will help you, like I said, you should raise it. Now, it's important for me to say that these presumptions aren't guaranteed. They're actually rebuttable, meaning that the government can, if it so believes, push back against your claims. But if it has concrete evidence that your financial circumstances will indeed become better soon. Now let's move on to the next factor, whether you've made good faith attempts to repay your loans. This looks at your past. Now, overall, case law has developed such that your loans will not be discharged if you somehow willfully contrive a hardship in order to discharge student loans. You can't kick yourself and ask for your loans to be dismissed, in other words. Now, this factor also assesses your efforts to find work, maximize your income, and minimize your expenses. In other words, what have you done in the past to help yourself? In many ways, this factor considers if you've been financially responsible. These assessments still stand, but the guidance, as I said, will presume you've acted in good faith if you've done any of the following things. You made a payment. It says a payment, not even multiple. Second, you applied for a deferment or forbearance. Third, you applied for an income-driven plan. You applied for a federal consolidation loan. You responded to the outreach from a servicer or a collector. And quickly, as you can see here, the guidance is quite lenient. And it'll also presume that you acted in good faith if you did something as simple as, and I want to quote this part of the guidance, if you did something as simple as meaningfully engage, if you engage meaningfully with the education department or their loan servicer regarding payment options. Out of all of these factors, the most helpful one seems to be if you've enrolled in an income-based plan. And even if you haven't, the guidance directs the government to consider why you haven't. For example, if you experienced, let's say, any errors or malfeasance from your servicer. As I'm sure you know, one of the most frustrating aspects of student loans is dealing with your servicers. Hour-long wait times are common, and poor advice is also unfortunately common. It's also common knowledge that student loan servicing has been plagued by administrative errors. Many of them, in fact, have been sued on multiple occasions for violating consumer protection laws. So the guidance acknowledges this and gives you the benefit of the doubt for not enrolling in a plan. So even if you don't meet any of these requirements, the guidance gives you yet an extra opportunity to explain why. Now, what if you have assets, exempt assets, like a car, home, or retirement account? Would that be factored in? Now, quickly, exempt assets are assets that the bankruptcy system allows you to keep so long as their value isn't beyond a certain amount. Now, even if you can keep them, my question is, should the law consider these assets in determining whether you should pay back your student loans? Now, courts around the country have not reached a unanimous decision on this question. Some courts, notably in Western and Northern New York, have ruled that these factors should indeed be considered, while others have ruled that they should not. The guidance, however, takes a much more lenient approach. It states that the government, attorney in this case, should not give dispositive weight to the existence of assets that are not easily converted to cash or otherwise critical to your well-being. So it recognizes that, for example, selling a primary residence or pulling from your retirement account can be an extreme measure, and that's how the guidance treats assets like this. I hope I've explained how this policy has made the process much easier, but the data from this program will be even more convincing. And here's why I go into the paper. Now, in this study, Professor Iuliano hand-collected all student loan adversary proceeding cases filed during the first year of the policy in 2022 through November of 2023. Overall, this study analyzed 652 cases and found that among those that reached a final outcome, 87% resulted in a full or partial discharge. Let's review these numbers. With respect to outcomes, Iuliano categorized the resolutions into three categories: successful, neutral, and unsuccessful. Successful ones resulted either in a settlement where the creditor offered to discharge the debt, that resulted in a default judgment where the creditor didn't put up a fight, or third, a discharge on the merits, where a debtor went to trial and won. Now in this category, as I said earlier, 87% settled for a full or partial discharge. 1% ended in a default judgment, and only one case ended with a decision on the merits. Neutral cases were those that were either dismissed without prejudice or with prejudice. A dismissal without prejudice occurs when a case is dismissed for some sort of technical error, but it can be refiled after the error is corrected. For this category here, 10% were dismissed without prejudice and only 1% was dismissed with prejudice. Now, with cases dismissed without prejudice, Iuliano points out that in all likelihood, these debtors dismissed their own cases because they secured some sort of settlement outside of court. He reviewed these cases individually and found that in several, the parties jointly stipulated to dismiss the case, with each side bearing its own cost. Now, he believes that this is a strong indication that debtors received favorable settlements. And regarding unsuccessful cases, these are cases in which the debtor was denied, they lost. Here, only 1%, which is 6 in total, were found in the data set. In 4 of these cases, the government determined that the debtor did not meet the requirements. What about the profiles of these people? And would you be the type of person to succeed? The paper found that the average age of debtors is 47, with the median age of 46. The youngest person was 24, and the oldest, 76. The average amount of assets held by a debtor is $75,000, with a median of $23,000. And I would say that this indicates that a small number of debtors hold substantially more assets. So don't let those numbers scare you away too much. In terms of student debt, debtors owed an average of $115,000, with a median of $77,000. At the tails of the distribution, the top 1% owed more than $540,000, with the highest debtor owing just under $700,000. At the other tail end, debtors in the lowest 10% owed less than $20,000, with the individual owing the least, $21,003. Now, these individuals were also balance sheet insolvent, meaning that they owed more than they owned. For example, the average net worth is negative $134,000, and the median is negative $94,000. These individuals are also cash flow insolvent, meaning that their expenses exceed their income. Now, the mean monthly income is $3,300 with a median of $3,000. And the mean monthly expenses are $3,500 with a median of $3,100. Now, how about the amount of debt discharge? For those who fell in the successful category, borrowers eliminated an average of $85,000 with a median of $67,000. If you're successful, your results are great. Those who received relief eliminated an average of 97% of their student loans, and the median amount eliminated was 100%. One last factor that stands out to me is whether someone was represented by a lawyer. Now, interestingly, 11% of the sample represented themselves, and of these, 61% succeeded. Now, you should take this to mean that even if you do this on your own, you have a better than 50-50 chance of winning some relief. Your chances are better than basically flipping a coin. Those are chances most people should take. This, of course, will require a lot of work though. But if you follow the instructions and put in the effort, you can get it done. And of course, if you need coaching, you can always contact me, which is why I created this video. Cases are also moving faster. In 2007, these cases lasted an average of 392 days. In 2017, the average fell to 334 days, and after this reform, to 266 days. So overall, people are winning more and doing it faster. The pressing question I'm sure you want to ask is, how long will this last? My answer is, unfortunately, I don't know. But I would guess not forever, but allow me to make an educated guess. Now, I say this because this is merely a policy. It's not a law, and it can be rescinded at any time. In fact, I'm a bit surprised it hasn't been formally rescinded. After all, it is difficult to determine whether the government has already informally disregarded it. This policy was implemented during the Biden administration, which adopted a more lenient and cooperative approach to student debtors. Now, the Trump administration is more combative and less willing to discharge student loans. For instance, they've fired numerous employees from the education department and even attempted to abolish it entirely. This approach to the Department of Education is critical because this department collaborates with the Department of Justice on these student loan cases. They send your loan information to the DOJ to help them assess your case. The administration also recently announced that it will garnish the wages of borrowers in default. This is a much different administration, to say the least. Now, at the same time though, the DOJ might not have the capacity to vigorously defend these cases right now, and certainly not the way they did in the past. A recent article in the New York Times reported that DOJ attorneys are depleted and distracted. The article pointed out that rank and file attorneys worry that they won't be able to identify and stop terrorist plots, cyber attacks, and mass violence. And so, let me say this, your student debt is important. Let me say that. But compared to these other responsibilities, I wouldn't say that they have the same priority. They shouldn't. Now, their lack of focus may work in your favor. Vigorously fighting you over your measly student debt, again, it's important, but fighting you over that student debt may not be worth their time nor their energy. So aside from the broader concerns about this administration, this could be a favorable opportunity for you. Bankruptcy should not be your first option. In fact, it should be your last resort, and only after you've attempted all that you could to fix your financial circumstances. But if you reach the educated decision that bankruptcy might be the best options, then you should reach out to me. You can find me at ariasesq.com. That's spelled ARIAS, E as in Esquire, SQ.com. Or you can just send me an email directly at jonathan@ariasesq.com. That's spelled JONATHAN. Or even more intimately, you can give me a call at 914-768-1498. Just give me a call and I'm here to help. Thank you for listening, and I hope this episode was helpful.